If a defendant is charged with a qualifying offense and makes bail, and while he's out, he gets rearrested on a non-qualifying offense, can that judge impose bail? To find out, you have to read People v. McGinley-Liddy, but it's 11 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People v. McGinley-Liddy. The citation for this case is 2025 New York Slip Opinion 03645, published by the New York Court of Appeals on June 17th of 2025. The issue in this case is whether a person who's out on bail on one charge, and while he's out on bail, he gets rearrested for a different offense that's a non-qualifying offense normally. Is that new non-qualifying offense a bail-eligible offense now? To understand and appreciate the context of this case, the helpful background to know is that in 2019, New York legislature passed a series of criminal justice reforms, including bail reform. And one of the bail reforms was that they created two different categories, qualifying offenses and non-qualifying offenses. Qualifying offenses would allow a judge to impose bail, non-monetary conditions, or even remand in certain circumstances. But non-qualifying offenses, the judge could not impose bail, could not impose remand, could impose non-monetary conditions, right? And after creating that criminal justice reform, there was a backlash, and legislature passed reforms to the reforms. And in 2020, they added CPL, Criminal Procedure Law, 510.10.4T, 510.10.4T, which expanded what a qualifying offense would be. Under that section, 510.10.4T, a qualifying offense now includes, it's called the harm on harm statute. If a person is out, either released on her own recognizance, released on conditions, or is yet to be arraigned on a crime, on a case where there's harm to a person or property, a specific person or property, and while they're out in those circumstances, they are arrested for another crime involving harm to a specific person or property, right? So harm in the first and harm in the second. That second offense that they're out on, that they committed while they were out on the first, is bail eligible even if it's a non-qualifying offense. That's what 510.10.4T says. So, for example, petty larceny is a non-qualifying offense. A person gets arrested. Well, let's get to the actual scenario here. In 2022, this is the facts here, or the alleged facts. In 2022, the defendant was arrested and charged with several felonies, including attempted murder, which is a qualifying offense. He made the bail that the judge in the Bronx imposed. While he was out on the bail, he goes to Queens, and he's arrested for larceny, amongst other crimes. Now, at that arraignment on the larceny, which is normally a non-qualifying offense, the prosecutor said, "Hey, judge, I know it's normally a non-qualifying offense, but I want you to find this is a qualifying offense because he was released on the condition of bail from the Bronx, and now he's been arrested for another crime that has specific harm to a specific person. The first was harm to a person, which is attempted murder. The second is harm to property, which is the larceny, or harm to a person for stealing their property. And as a result, the harm on harm statute applies, and I want this otherwise non-qualifying offense to be bail eligible." The judge agreed and imposed bail. The defendant appealed this, basically filed a habeas petition saying, "I'm being held illegally," and the appellate division disagreed with him and found the judge did the right thing, and it goes all the way to the Court of Appeals. And here, what the Court of Appeals holds, because the question is bail, which is a monetary condition, is that satisfied? Does that satisfy the requirements of 510.10.4T, which says either released on their own recognizance, released on conditions, or is yet to be arraigned after the issuance of a desk appearance ticket for a felony or a misdemeanor? And the Court of Appeals says, yes, it does satisfy, because bail is a condition of release when it's imposed. If a person makes the bail, they will be released from custody. Thus, bail is a condition of release, and a defendant who posts bail has been released under conditions, which is the language used by 510.10.4T. Therefore, a person who's out on bail and commits any kind of offense, any kind of a misdemeanor or felony that relates to harm, and if they're out on bail for a harm-related crime, the harm on harm statute of 510.10.4T will apply, and that second offense will be bail eligible in the discretion of the court. And that's the case of People versus McGinley-Liddy. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.